So can everybody see my screen okay? Perfect. So again, like Dr. Brent said, my name is George. I'm going to be presenting my senior honors thesis that I've been working on with Dr. Brent over the last year. So a special thanks to him for putting up with me and all the encouragement and support he's given me throughout it. But today, it's my paper is called "Identifying and Closing the Gap in Judicial Decision Making." Um, so judges have my thesis, my general idea is that judges have been faced with various theories suggesting how they ought to make judicial decisions and rulings. Some people like Professor Stanley Fish offer loose restrictions, while others like Ronald Dworkin impose more strict or tighter guidelines under judicial discretion. And then others like Hart and Posner are somewhere in between. However, in considering these theories and how they work with one another, Hart and Posner also suggest that there are these cases that face jurists that can be considered hard. And that means in the sense of that there is no clear precedent or law that guides the judge and how to make this ruling, right? So consequently, they suggest that the judge in these hard cases generally has judicial discretion. And Posner offers himself a little bit more. He's a former judge, a federal judge, and he offers some further limitations of his own in these cases. But I suggest that there ought to be even further guiding principles in resolving the cases of this sort, namely what I'll get to and call the progression of morality and American civic virtues. So generally, my thesis boils down to the idea that the current theories of jurisprudence are either too limited or too loose in guiding judges, so there is a gap that needs to be filled. I'm going to spare everybody the sake of discussing the Fish-Dworkin debate because it does get a little aggressive between the two of them. But I will say again that Fish offers a theory which I consider to be a little too loose, Dworkin a little too strict, and I offer critiques of both of them in my paper. But I'm going to skip over that just to get to the core of my argument, which is identifying and closing the gap. So again, Hart and Posner are sort of in the middle ground between Fish and Dworkin. So they both suggest that there are general restrictions of interpretation, professional conduct, and judicial consensus that Fish suggests, and that there are more specific restrictions like how judges ought to consider precedent and other aspects of law, which Dworkin suggests. But they both again claim that many of these cases fall in between and are again titled hard cases. And again, Posner and Hart claim that judges have this broad, almost legislative discretion when deciding these cases. And Posner even adds that the Supreme Court, due to its lack of superior restrictions, takes on a legislative role more often than other courts or judges do. So this legislative discretion is kind of the gap that I want to fill just a little bit more with my theory, just because it seems we often consider judges to be adjudicating or interpreting the law rather than legislating or creating law in our theory of the judicial branch. So then I get to this idea that I want to maintain, I maintain that to close this gap, judges and justices ought to be further constrained by the importance of maintaining the moral legitimacy of their decisions and their courts, or in their courts, and which will also seek to progress morality by upholding our American civic virtues. The moral legitimacy of a decision is of particular importance because it offers an avenue for justifying why the public and other political actors should follow the law and why these decisions are justified in binding subjects to their rulings. And I borrow my concept of moral legitimacy from Professor Richard Fallon, and he offers four criteria that give a kind of spectrum of moral legitimacy. The first one being that judges or justices use a reliable or accepted interpretive method of historical facts and interpreting the law. This is kind of a general idea that judges have to use an interpretive lens that is accepted, and that can be any sort of typical consensus, right? That so we often see judges and justices using originalism and textualism, or even living constitutionalism, and many things in between, right? So it doesn't have to be a specific lens or a specific interpretive lens, but they do have to use one that is reliable and well accepted in the legal field. The second criteria he offers is a reasonable understanding of precedent, because when we consider laws or when the judges and justices consider laws, they ought to consider them in a similar manner that they did previous cases by other judges or other courts, to create a sense of justice and equality, right? The third criteria then is that justices and judges ought to adjudicate the law and interpret the law in good faith and in consistency with their previous jurisprudence. So rather than making decisions however they please, however they like, and justifying that their ruling with any sort of evidence or persuasive argumentation, that they have to address a case with good faith, that they are going to apply the law as best as they can and as consistently as they can with their other jurisprudence. His fourth criteria is moral reasonableness. And this is obviously a very vague term, but the general sense of what this is trying to get at is the idea that there is a minimum moral content in the law. So judges should not be making decisions that would be morally reprehensible. For example, ruling in a way that would implement, extensive racial disparities or slavery again, right? That would be an absurd example, right? But just to get the idea of what it really is trying to get at. So I supplement his theory of moral legitimacy with my fifth criteria of moral progression. So that laws must not only maintain kind of a minimum content, but in these hard cases, to maintain moral legitimacy, they ought to pursue an ideal morality and progress that idea. So again, generally speaking, when a judge is faced with a hard case and is left in a position that Hart and Posner might suggest would give them a legislative role in deciding a case, I would simply suggest that instead that the judge or justice ought to be bound by the ideas of moral reasonableness and moral progression. Because these types of decisions or decisions that uphold these values and moral legitimacy or maintain moral legitimacy and therefore garner respectworthiness and obedience from citizens and political actors within the United States. All that to get to my point of how I think we should close the gap. And this is the idea of moral progression. And I keep saying that, and it's very vague up until this point where I'm going to try to make it a little bit more specific, a little less vague. So moral progression in this sense is what I want to consider the development of American civic virtues, especially since these are the values that we hold most dear in understanding American political thought and understanding how we function in society. And in the United States, we often consider those to be the ones that are enumerated in the Constitution as rights. These are the virtues that we hold dear to ourselves and kind of mobilize us, right? These can include life, liberty, the pursuit of happiness, equality, freedom of speech, freedom of assembly, due process, and so on. I'm sure if I were to ask anyone else in the audience, they could give me another few, if not a bunch more, right? And this is really important because this is what most of the court's work is evaluating today, right? They're evaluating possible encroachments of these rights. So they ought to progress the upholding of these rights. So then again, you might all be concerned and ask me, well, George, these are not civic virtues because they're not applied in that way, or at least we haven't seen them applied in that way, right? Because we haven't seen equality and justice been applied equally to all people of different groups. And I think that that's a very valid point, right? That these rights and virtues have not been upheld throughout American history, and in many cases are still lacking today, right? In particular, liberty and equality have been absurdly disregarded, especially with a history that is so entrenched in slavery and racism, right? But I want to suggest that though these values are often not applied in this right way, we often consider them to be the founding principles of the nation. We often consider them to be the ones we are willing to fight for and pursue. So as they are written and as they are pursued, these are the values, the American civic virtues that do mobilize Americans as individuals and as communities to affect change. And then again, I mean, maybe a textualist might critique me by suggesting that the founding fathers did not intend for these rights to be applied in this way, right? I don't think that right, just because the founding fathers did not foresee non-white, non-male, or non-wealthy individuals to have these rights or benefit from these rights does not mean that these aren't the values that ought to be embodied and are valued in our American society. So this is the way I define American civic virtue. These are the values then that judges in these hard cases ought to be progressing in their in hard cases in their jurisprudence, right? So what does that look like? And this is kind of the final concept that I'm trying to get at here, is that judges ought to be partaking in a practice or a thought experiment that is commonly known as the original position or the veil of ignorance, that is developed by philosopher John Rawls in his book, The Theory of Justice. And this theory is an attempt to kind of create a moral society that is free and equal and would be one that is desired by most, if not all, people in the society, right? But so that for those that aren't aware of what the original position or the veil of ignorance is, it's a thought experiment that requires that the person making this decision or making this ruling puts themselves kind of in an original position before the society was created, and be behind a veil of ignorance of not knowing what race, what age, what gender, what sexual orientation, what socioeconomic status they would have. And they're, from that point, try to make laws or rulings that would be fair, that they would be willing to endorse. So what I argue is that to maintain the moral progression of American civic virtues, which would therefore maintain moral legitimacy and maintain the respectworthiness of the decisions, that judges ought to be putting themselves in this position when they're creating these laws. So I have a few cases that if this type of jurisprudence was practiced, would probably have been decided a little differently, right? So, for example, one of them, the most, I think, notorious or most controversial in recent history is Citizens United versus FEC. And this is where the majority in the Supreme Court maintained that political speech is indispensable to democracy, which is no less true because the speech comes from a corporation, right? So they suggest that that corporations have equal opportunity to be a part of this democracy, but they overlook, if they were to be in the original position, the idea that progressing American civic virtue would include of maintaining the virtue of democracy, which is typically in the United States considered to be one vote, one voice, equality among others in their participation in politics and civics. And with this case, they instead regress that American civic virtue, right? So it's no longer democratic when the people that democracy governs are no longer allowed to participate in political speech, or at least drowned out by larger, less representative political voices, which the corporations are. So as Justice Stevens in his dissent suggests, that there are compelling government interests to curb corporations' abilities to spend money during local and national elections, because they do degrade our sense of democracy, that this case or this ruling would be morally regressive and not maintain the moral legitimacy that it ought to. I know I'm running out of time, so I'm not going to go into the second case. But I will be back after my philosophy capstone to answer any questions, because I'm sure I left many people confused. But I will say also that I think this might be an interesting topic for me and Thomas to look at some of the other qualified immunity cases, if we were to apply this jurisprudence and see what it would look like. But yes, thank you again for listening.
Thank you very much, George. And thank you, Thomas. We really appreciate it. And we look forward to seeing you back here to adjudicate questions as time goes on. Next, we have